All right, welcome everyone to the Greater Delray Beach Chamber of Commerce's weekly webinar. We hope you had a chance to unplug last week and just relax a little bit. This week we're super excited to have Mr. Ron Kaniuk here. He is kind of our professional webinar host because he's done several of them for us today to talk about contract clauses that you should know about. So please be aware, just in case you have to leave a little bit early or you're coming a little bit late, all of our webinars are recorded and uploaded to YouTube, Facebook, and the Chamber's website underneath the webinars tab. And at this point, I'm going to go ahead and turn it over to you, Ron.
Thanks, everybody. Thanks, Angel. Give me 1 second to get set up. And away we go. So the presentation is webinar, contract clauses everyone should have. Agreements in general. Legal agreements often seem complex to outsiders and non-attorneys. By looking at each provision separately, you can better understand how to structure terms to benefit you and your company and what obligations you have under each agreement that your business is a party to. Agreements are living documents. They need to be maintained and updated to keep pace with changes in the law, customized needs, and circumstances. Contracts amid coronavirus. So unfortunately, but not unsurprisingly, businesses are suffering significant side effects from the bitter pill of our societal shutdown due to COVID. Parties are finding themselves unable and sometimes unwilling to fulfill their obligations under a variety of agreements, including mortgage, leases, service and sales contracts, etc. However, while circumstances have changed due to COVID, the law has not. So the same framework of rules that applied before COVID-19 are equally applicable now. And the question is how the facts apply to your current contractual situation and what concessions each side is willing and able to make in order to salvage or reform a transaction. So business organizational documents. For your company, buy in between owners. Owners can be individuals or businesses. You should all have operating agreements for LLCs, shareholder agreements for corporations, partnership agreements for partnerships, and joint venture agreements between your company and other businesses for joint venture projects that you engage in without a merger of the business operations. So you need to do an inventory of your existing agreements. Identify the type of agreements that your business is a party to: mortgage and leases for real property, contracts for purchases or sale of real property or for services, employment contracts, licensing, distribution, etc., user agreements, privacy policies for the website. Identify the parties to the agreement. Your company should be the party to the agreement. You should never use your individual name. And then the other party would be the other party to the agreement. Never use your individual name. You eliminate your personal protection from personal liability. Review the key provisions of each agreement, the term, the fees to be paid or received, timelines, force majeure provisions, and more. So COVID-19 implications. You should conduct a special COVID-19 analysis to review the effect of the shutdown on your business operations, present travel restrictions, group gathering restrictions, and essential or non-essential business rules. See how these issues affect your company and the contracts and agreements that it's a party to. Explore the best ways to mitigate losses if performance is impossible, and review enforcement and penalty options if you fear the other party will fail or refuse to perform. So parties to the agreement. The most basic question to be addressed involves who is bound to the agreement. Any agreement should be signed by your company and the party with whom you are making a deal. As I said earlier, this is important and essential for ensuring that you are protected from personal liability. You can generally only sue the party that signed the agreement, so that makes a big difference too. Connected to this is looking at the asset base of the person entity bound by the agreement. Do they have assets, and will they be able to pay damages in event of default or dispute? I was just dealing with this morning on a call with a potential client. He's working on a deal where his partner is going to buy him out of the business. They're going to do a contract for services with another company. And I said to him that he's got to get the his partner to personally guarantee performance of the other company's contract, so that if he doesn't get paid, he has somebody to go against, as opposed to just going against a company that might be a shell to protect from liability. So related to that is the question of what parties are bound is the personal guarantee. You want to try and get a personal guarantee if you're signing a contract with somebody, and they're going to want to try and get a personal guarantee from you. It bypasses the protection from personal liability that a corporation and the corporate shield provides. So you need to be very, very careful about how to do that. Prevailing party provision. In Florida, each party to a lawsuit must usually bear their own costs and attorney's fees. There's two exceptions where the plaintiff has a specific Florida statute that provides for fees, or where attorney's fees are provided for in the agreement. So an attorney's fees clause can prevent meritless lawsuits and will greatly aid in recovering what is lost by the prevailing party. This clause can directly save you thousands of dollars in legal fees, so make sure it's included in any agreement that you have. Terms and conditions. This clause might seem obvious, and it should be obvious, but many business owners fail to specifically describe the terms of service. What is required and not required, and what is the time frame for performance? Including what your business is not responsible for is essential for clarity and peace of mind in case of a lawsuit. A clear and unambiguous terms of service section puts each party on notice to the exact requirements, leaving no room for ambiguity. So notice provision. A notice clause states how the parties to an agreement communicate with each other in written form. When communications are sent between parties, you don't want the other party to be able to claim that it was not received. This clause avoids that situation. Your notice clause can permit communications via email and should provide for a copy to be sent to your attorney. As the lawyer for a deal, I always want to get notice for what the other party is alleging is or is not going on properly. Employment issues. You should consider having signed employment agreements with all types of employees, regardless of whether they are full-time, part-time, or independent contractors. In addition, you should strongly consider having a written employment manual, which should be distributed to all employees with a signed acknowledgement of receipt. You may also want to prepare and distribute a return to work memo if you have or are in the process of reopening from COVID. Confidentiality, non-disclosure. Many commercial agreements contain one or more clauses on confidentiality. It's standard that you want to keep sensitive information among the parties without leaking it out to third parties not party to the agreement. It's important to consider the scope of the confidentiality provision. An overly broad provision may be an administrative burden, lead to unintended violations, and be difficult to enforce. A narrow provision may not protect the secrets for which it is intended. Non-compete, non-solicitation. Many agreements, particularly partnership and or employment agreements, will call for non-competition and or non-solicitation clauses. The non-competition clause prevents a party from competing against the other using the information from their prior relationship for some period of time. The non-solicitation clause typically prevents one party from taking the employees, customers, or other commercial relationships of the other party for some period of time. Both are generally important clauses to include in an agreement, and both have a lot of commercial protection for the parties. It is important to carefully tailor these provisions to be meaningful and enforceable. Contractual authority. You want to make sure that the businesses and the individuals signing on behalf of those businesses have the authority to enter into the agreement, and that the agreement will not violate unrelated agreements with third parties. You want to get a corporate resolution as an attachment to any agreement to provide protection to show that they had that authority. Moreover, if party A and B are entering into an agreement, it is not uncommon for party B to want to make sure that party A is not violating an agreement with party C, who might sue party B for breach of that agreement and might sue party A for interference with it. You might also want to get an indemnification clause to protect against such a situation. Assignment and subletting. Often there's a personal relationship Often there is a personal relationship between the parties to an agreement. This is often the case in a residential landlord-tenant relationship or in other commercial relationships. Most agreements provide that the agreement can't be assigned to a third party without consent of the other party. This is part of subletting without the landlord's consent, or to transferring who's responsible under the agreement. Drafting like this is neutral, prevents both parties from the eventuality discussed above. However, it would not be unusual to seek a one-way obligation to seek consent to assign if the party seeking to impose that obligation on the other party has concerns as to who might end up occupying the property or providing it with services or products. Merger integration clause. In most agreements, you will find a merger integration clause, which provides that all prior agreements among the parties are brought together in this agreement. This is usually desirable because we want a contract that is complete and is the only document governing the relationship among the parties for that particular item. Severability clause. A severability clause upholds the sanctity of an entire agreement, even where the court finds one clause to be unenforceable. Your agreement should be designed to give you the upper hand in case of any litigation, and many parties have lost their case because they failed to include a severability clause in their contract. Dispute resolution provisions. Usually buried towards the end of the agreement is the dispute resolution provision, which provides for the procedure if you end up in a dispute, mediation, arbitration, and/or litigation. You want to decide which of all of these options you want to pursue and which you want to give the other party the option to pursue. Forum selection, venue provision. Especially when dealing with out-of-state customers, contractors, or suppliers, being the home party in any lawsuit has a great cost advantage. Your agreement should clearly indicate that upon any dispute over its contents, venue is proper in the state of Florida and in the specific county where you're located. You will also want Florida law to govern your dispute. This may sound redundant, but leaving this element out can be disastrous in litigation. If you're viewing this from a state other than Florida, you're going to want your state to control. Indemnification. As I indicated when I was talking about some other clauses, an indemnification clause shifts risk from one party to another. It often kicks in when one party to the agreement violates the rights of another person or entity, typically a non-party to the agreement, and the party that didn't violate the agreement wants protection and wants to be repaid its losses. For instance, if both party A and party B sign an agreement, party A violates the rights of party C, the indemnification clause will allow party B to seek compensation from party A if party B is sued by party C. No partnership or agency. Agreements frequently contain boilerplate provisions stating that the relationship between the parties is not to be construed as a partnership or agency. This is because both of those legal forms may arise implicitly without the parties realizing that they have done so. Both have a range of legal and tax implications for the parties. If the parties don't intend for them to arise, it may be safer to state expressly that the contract does not either form either relationship to ensure that no unintended consequences flow from the agreement. Termination and damages. Savvy business owners will include an early termination and damages clause in their agreements. This clause gives you an out just in case performance under the agreement becomes either impossible or financially detrimental to the business. Termination clause can be tricky to create, must be properly drafted, and should also state specific damages, if applicable, that each party is entitled to in case of early termination. Limiting your damages in case of breach can be a make or break difference in the viability of your business. Event of default. The phrase default or event of default is a fixture primarily in loan agreements and real property leases where one or more occurrences give the landlord or lender the opportunity to terminate the agreement. Examples include failure to pay, failure to comply with terms of agreement, or bankruptcy, insolvency of the company, and sometimes one or more principals of the company. Waiver. In the absence of a waiver clause where a party fails to take action in respect of a breach or default under the agreement or delays in taking action, that party may lose its right to take action in respect of that breach of default. A waiver clause is designed to ensure that a party's rights, powers, and remedies will not be lost as a result of any delay or omission in exercising or enforcing those rights. Force majeure. Force majeure is a common clause in agreements that essentially frees both parties from liability or obligation when an extraordinary event or circumstances beyond the control of the parties, such as an act of God, act of nature, or national emergency, prevents one or both parties from fulfilling their obligations under the agreement. In practice, most force majeure clauses do not excuse a party's non-performance entirely, but only suspend it for the duration of the force majeure. This topic is going to be heavily litigated in the months to come. Is the COVID a force majeure event? Was it a national or local event? How long did that emergency last? When was that emergency over? What effect was Governor DeSantis's failure to declare an emergency or failure to require certain behaviors evidence of that being a lack of an emergency, or is there other cause on a local level to indicate that it applies? Refund requests, chargebacks. It's critical that you implement a strategy for dealing with refund requests and avoiding, reducing, and disputing chargebacks. This will help you ensure positive interactions with your customers and will put you in a position to recover disputed revenue and prevent future chargebacks, making a winning chargeback strategy an investment that will continue to pay off long after things return to normal. Refund requests and chargebacks, some suggestions: use multi-level fraud detections, optimize your response, deploy smarter chatbots on your website, adhere to best practices of credit card companies' merchant services, make cancellations easy when possible and offer alternatives, roll over registration of future events, redirect fees to other programs and benefits, and offer optional donations. Bankruptcy overview. Bankruptcy could be the subject of an entirely separate webinar. The U.S. Constitution gives Congress the authority to enact bankruptcy laws for the entire country. Current law was enacted in 1978. Bankruptcy Reform Act codified in Title 11 of the U.S. Code. Major changes were made in 2005 in the Bankruptcy Abuse Protection and Consumer Protection Act, BAP-CPA. Recent changes were enacted via the Small Business Reorganization Act of 2019, and technical fixes were included in the CARES Act. Chapters 1, 3, and 5 of the Bankruptcy Code are procedural. Chapters 7, 9, 11, 12, 13, and 15 are substantive and deal with each type of bankruptcy. 7 for personal liquidation, 9 for municipalities but not states, 11 for corporate reorganization, 12 for family farmers, 13 for individual debt adjustment, which is a personal Chapter 11, and Chapter 15 for ancillary and cross-border insolvency. Debtor has special powers in a bankruptcy case. First, upon filing a bankruptcy, there's an automatic stay, stops any and all litigation and collection efforts against the debtor. Bankruptcy Code gives debtors the power to reject leases and executory contracts, thereby reducing obligations on a going forward basis and giving debtors a stronger hand in negotiating with landlords and vendors. This is going to be, a little modified by whether or not there's a personal guarantee. If there's a personal guarantee, then the corporation is going to get out of the lease or contract, but the guarantor is going to have a problem. And then DIP financing, debtor in possession financing. Debtors can obtain special financing from lenders who can obtain priority over other creditors. Residential mortgages and evictions. Residential mortgage foreclosures and landlord-tenant evictions were suspended until July 1, 2020. There have been multiple extensions of this deadline. It's possible it may be extended again. This is a state-mandated change to any existing mortgage or lease agreement. These rules do not apply to commercial properties. Concluding thoughts. Despite the significant changes to our lives due to COVID-19, many of the issues affecting businesses and business owners remain unchanged. Successful businesses have complete and accurate records, especially as it relates to business agreements with other parties. You need to identify, organize, and inventory your business records now, and you need to consult with professionals, attorneys, accountants, realtors, business advisors who can save you time and money. And then I'm going to stop the share and open it up to questions. So feel free to ask any questions that you have. No questions. Either I was really good or nobody's paying attention.
Yes, if anybody has any questions.
I hope it's that I was really good and that I answered any questions that you have. And if you have any questions, I'm available for phone calls and free consultations, and invite you to contact me.
You're just so clear on your information. Like,
I hope so. Otherwise,
there's,
everybody's really confused and doesn't know what they want to ask.
there's no stone left unturned with you. Oh, hold on. We have a hand raised. I'm not sure who raised that. But if anybody has a question, please go ahead and type it in either the Q&A box or the tab, or the chat box. I'm sorry. Let's see. Miss Missouri did say thank you so much. Oh,
So I
we have
appreciate
one.
it.
Perfect.
I mean,
How does
Florida-
Florida deal with
Florida
force?
deals with force majeure clauses the same way everybody else does. They're going to be evaluated on a case-by-case basis. They're contract specific. They're circumstance specific, and it's definitely a topic that's being litigated or being threatened for litigation as everybody tries to negotiate amendments to leases and contracts that people are having trouble performing under.
We do have another question. Are most of those clauses included in the FAR bar as is? Did I say that right?
That the FLAR bar as is a real estate contract. Most of these provisions should be included, but I always like to modify them and make sure they're as structured as much as possible in favor of my client.
Perfect. All right.
And the other thing, and I just want to add this because I had this phone call today. So I have a client who has a business with a partner, and they got an EIDL loan for about $50,000. And now my client wants to sell the business. And my client said to the other partner, and my client says to me, what about my guarantee under the EIDL? And, my answer to, and this is what happens when you have other contracts that are separate from the contract that you're governing. So I said to him, number one, you can't get released from any obligations you have under your EIDL loan in connection with your sale unless the bank and the SBA sign off on it. The best you can do is get a release and indemnification from your partner. And then if something goes wrong, you're going to have to sue your partner. So it's important to, inventory all the agreements that the company has entered into, and then know what your risks and liabilities are.
Perfect. We did just get another question in here, Ron.
In revising a new business plan and future goals innovation to protect loss of intellectual property and potential inventors. Don't fully understand the question, but you should definitely, do everything you can to protect your IP and preserve your. You should register your patents and intellectual property, and you should, clearly identify who the owners of it is. When clearing up potentially ambiguous terms in a contract and email exchanges between parties, clearing up these areas up become part of the contract. Now, the answer is you can argue that they do, but I would much prefer that if there's disputes, if you enter into a contract and then there are disputes over things that you both should have made clearer in the contract, and you exchange emails that clear that up, or you exchange phone calls that clear that up, then you should put the new terms in a separate writing as an addendum that says, notwithstanding the contract, we've agreed to the following clarifications, modifications, etc. The more you have in writing, the better off you are. I mean, email is going to be better than nothing. I have a client right now who's being sued on some violation of non-disclosure and non-compete provisions, and he maintains that they had an understanding about what they were doing. That understanding was verbal. He has no written documentation whatsoever to back it up. So, having email is better than having nothing, but having a signed addendum by both parties is better than email.
Right. All right. Does anybody else have any other questions?
U.S. Patent and Trademark Office emails. Again, you know, you're going to want to file your trademark or property, you know, intellectual property. You're going to want to do everything that you have to do. The emails are going to be a backup, but you want it registered, and you want it fully registered and protected. And for that, I refer out to IP lawyers.
All right.
So as always, I appreciate the opportunity to speak with you. I appreciate the opportunity to chat, you know, to do this with the chamber and be a resource. And if you have questions, 561-292-2127, Ron at KaniukLawOffice.com.
Wonderful. Thank you so much, Ron. I'm sure you'll be back probably in September, as we tend to bring you around at least once a month. Your topics are always so well informative. Thank you again, everybody, for joining us this week. Please be aware that this will be on Facebook, YouTube, and the Chamber's website underneath the webinars tab. So you can always go back to this if you need to refresh your memory, or you want to re-watch it just to make sure that you have the information a little clearer. Ron's information will be provided as well. And we hope you guys have a wonderful week. Thank you for joining us.
Take care, everybody.